Hello and welcome to a video I honestly never thought I would be making. I'm MCFPapa. I won't bury the lead. Big Fish Games is being sued by GrandMA Studios. Now, for background, of course, late last year, GrandMA were callously terminated by Big Fish Games, and they were also forced to lay off a lot of their development team. And to be honest, I thought it would be like a total shutdown of GrandMA closing their doors entirely, but it seems like they at least have some life yet as a studio. This video is intended to at least bring light to the case, and I will be going into quite a bit of depth on what this complaint actually says, and hopefully in a way that's easy to understand, better than some of the legal jargon in it. And I'd like to shout out, of course, friend of the channel, the YouTuber Roamer Monkey, for doing such good journalism and helping keep me informed about all the latest Mystery Case Files related news over the years, including this. This is a Reddit post he made, showing off the Law 360 article where he found it originally. And I will have this linked in the description. You can look through plenty of the details yourself. But for this video, I just thought I would go through the actual lawsuit that was filed and break it down in a hopefully digestible format. Before I get started, just want to make it clear, I am not a lawyer. I have no legal experience or training or anything, and nothing in this video can be considered legal advice. Alright, that should hopefully cover all the bases. So anyway, this was filed on May 11th, which was Monday last week, in the King County Superior Court in Washington State. As you can see, the plaintiff is GrandMA Studios Limited, who seems to have relocated from Ukraine to Cyprus, probably due to all the conflict in the war and that going on. And the defendant is BFG Entertainment, which was the company that bought up Big Fish Games around like a month or two before they fired GrandMA. And the official title of the lawsuit is a complaint for damages, declaratory relief, accounting, and injunctive relief. Basically, all you need to know is GrandMA are wanting to get paid their fair share. That's what it means. Now, I'll just try my best to summarize this as best I can. So, in the introduction, it just lists the flaws that BFG Entertainment has done after the acquisition to GrandMA in a violation of their agreements, because GrandMA signed two agreements, one dated May 14th, 2012 and another August 22nd, 2013, and the agreements require monthly royalty reporting and payment, and provide revenue share for qualifying titles payable in perpetuity, including after termination. And then paragraph 3, they're just clarifying that GrandMA was quite successful for Big Fish and helped drive a lot of revenue and notoriety to them. I guess October 4th, 2025 was when it was sold to the BFG Entertainment, and I guess from the way it sounds, at least in this lawsuit, BFG Entertainment was just very poor at managing anything, because apparently GrandMA didn't actually receive the notice that it was sold until over a month later, right around Christmas time. And because they, of course, with any acquisition of business assets, they want to reduce as much cost as possible, they tried to rewrite and violate the contract so they could get out of paying what they were meant to, while also continuing to sell and monetize all of the GrandMA games they had made and published on their website. And now, in paragraph 6, they talk about how it wasn't minor, they were significant, and because I guess the previous owners of Big Fish at least valued GrandMA as a studio, but BFG Entertainment really didn't. It tried to force GrandMA into a replacement agreement that cut them off of any of their royalties. Of course, after GrandMA refused to agree to such a thing, then they fired all of them in the termination notice, where they just say that all the royalties and distribution and licensing rights are gone, even having GrandMA's mobile games removed from the app stores, even though the agreements were set in stone and concrete. They also talk about how BFG Entertainment didn't give proper reports to GrandMA that they were required to, and so GrandMA is seeking damages and also injunctive relief, basically ordering the judge to tell BFG Entertainment that they gotta actually hold up their end of the agreements from now on. Then Section 2 just talks about the jurisdiction is proper, which is kind of a weird thing. I guess in lawsuits you gotta at least talk about why the court's appropriate for it, otherwise it might get thrown out. But anyway, that's what Section 2 is. And then Section 3 just talks about that GrandMA is a company in the Republic of Cyprus. Which, I mean, if you're gonna get out of Ukraine, I'm not sure why you would choose Cyprus of all places. Maybe it's just insanely cheap to live and operate in. I don't know. But anyway, then BFG Entertainment is the Delaware corporation that owns all the legacy assets of Big Fish Games Inc., which I guess is still based in Seattle, Washington, at least. So then here is where you get into the meat of the lawsuit, where they talk about the game development agreements, where they would develop games and then Big Fish would pay both development fees for them and revenue share for their products after release. And this also requires that 45 days after each month that Big Fish receives money for a product, they gotta provide a detailed statement for that month and then verify, basically proving that they're telling the truth and paying GrandMA the correct amount of revenue share they're owed. And it says the 2013 agreement contains the same exact obligations. And the key thing, though, with these agreements is that revenue share remains payable for continued exploitation even if agreements are later terminated. So they're set in stone for eternity. You can't just weasel out of paying them. Yeah, it says it doesn't relieve Big Fish of their continuing obligation to pay revenue share or net revenue received with their games. And they may terminate the agreement upon 30 days of written notice, but also, again, they reiterate, that's the thing with lawsuits, they repeat themselves over and over just to make it crystal clear in the arguments that key provisions survive even the agreement being terminated, payment provisions and intellectual property provisions. The statements of work say that the revenue share in perpetuity is 40% on Big Fish's website's net revenue and 40% of the gross revenue through certain non-Big Fish channels. I assume that means like Steam or other storefronts that they try to sell the game on would still have GrandMA be entitled to the revenue share. And also they talk about how they can ask for recoupment of the development fees, but only for a specific game, not just Big Fish doing a generalized thing across all their games to get rid of the royalty payments altogether. Because it goes on to say that BFG Entertainment said that GrandMA had over $2 million in unrecouped advances that would exceed any future royalties to pay them, so that therefore they didn't need to pay him, they were terminated. Which, I mean, that's a really stupid thing to say, in my opinion. And anyway, you know, the biggest thing for BFG Entertainment to be able to recoup these $2 million advances would be if they had just allowed GrandMA to continue operating as a game developer making games for them. That would be a way for them to at least have more games to make more money with, but no, they had to just terminate them. And so basically that's all like set in the very foundations of the agreement. And then section B here goes on to the amendments to the agreement. First listing some of GrandMA's franchises. So how about this? Mystery Case Files is officially in a legal lawsuit document. Boy, has the series had a wide reach now. And now something interesting that I didn't know until this lawsuit was that under these agreements, GrandMA was granted exclusive mobile distribution rights for pretty much all of their games, where they're the ones who own the rights to the mobile versions, including many of their franchises. But of course the one that interests me the most is Mystery Case Files parts 21 to 29. GrandMA only made 9 MCF games, so therefore this is confirmation that Fragments of Truth and MCF story is part of the mainline Mystery Case Files series, not a spin-off, even though it has a different protagonist. How about that for proof? But anyway, just really interesting that they managed to have such good rights like that for the mobile versions. And anyway, then they talk about amendments that are just basically letting them make more games, or also prohibits GrandMA from offering sequels to third parties without Big Fish authorization. So I guess they just want to lock up all the IPs they can on Big Fish Games' website. So interesting to have proof of that, even though you could kind of guess from what goes on there. The 2017 also specifies revenue share in perpetuity and ties recoupment to the relevant sequel. So if they make a sequel, then they can take their cut of advances out of it. But also here, which is interesting, apparently with this amendment, GrandMA would get a $15,000 bonus when an additional sequel reached $350,000 in net revenue. So that's, I guess, a good bonus for successful performance of one of their games. And then in 2018, it revised several terms, including granting GrandMA all these buzzwords just mean it's a set in stone license to market and self-publish mobile versions of their games and sequels on mobile platforms, as long as they follow the correct criteria. And then the March 2019 amendment just says that GrandMA can't publish a mobile version until 61 days after the launch of it on Big Fish website. So that's, I guess, not too important. August 2023, though, these set the revenue share at 50% in perpetuity, and also grants the, I guess again, just setting in stone the exclusive, non-transferable, non-sub-licensable, non-assignable, royalty-free, fully paid license for GrandMA to publish their mobile versions by themselves. And then in 2024, it seems they just corrected the language of stuff and said that Big Fish is only entitled to recoup the development fees or advances paid after August 18th, 2023, and all the ones made before are governed by all the original stuff. So basically just a lot of amendments just making it clear that, like, GrandMA had a tight contract for working with Big Fish. And then this section talks about what Big Fish did when it was transitioning to BFG Entertainment Inc., and that the agreements were assigned to BFG Entertainment as a smooth transition of relevant assets. But it turns out it wasn't very smooth. And then they say how Big Fish Entertainment still had the obligations to do all the royalty statements and revenue share and such that they had under the previous owners of Big Fish. But instead, what they did was they sent GrandMA an independent contractor game development agreement, saying that all payment and royalty terms prescribed under original agreements are expressly canceled, terminated, and superseded. Basically saying, screw you, we want you to end all our obligations to pay you. And obviously, GrandMA wouldn't have agreed to something like that. It says also it would have made them just an on-demand contractor, terminating also any license for GrandMA to use or exploit the existing games or intellectual property unless they agreed in writing later on, and that they wouldn't be entitled to any compensation for any past services or anything. And of course also getting it out of Washington and into Delaware. I don't know if that's really important too much. I don't know what the legal system in Delaware versus the one in Washington is like. But they offered nothing to GrandMA for it. And then, of course, GrandMA refused this stupid thing, so then they issued the December 4th termination notice, which also says it terminated the agreements and any outstanding obligations of Big Fish Games Entertainment, including all the stuff originally listed, the royalties, any ongoing development or milestone payments, and all distribution and licensing rights. Saying that BFG Entertainment owed all intellectual property created from said agreements, and that GrandMA had no right to it in any capacity whatsoever. Whew, boy, real nice, wasn't BFG Entertainment? And something a bit funny is that apparently BFG Entertainment sent it to an outdated address that wasn't even mentioned since 2018 because they fixed it in an amendment, and to a non-existent email address, basically showing that BFG Entertainment had no idea what they were really doing. And then they demanded to make it mutual by having GrandMA agree to such a thing. And then BFG Entertainment says they would assume the termination was final even if GrandMA didn't respond within 7 days, which that's not how it works at all. But they just tried to pull a fast one, I suppose, and that's why they did it that way. And they even doubled down and threatened them by saying that they would have the GrandMA software applications and games removed from the app stores because they were infringing on BFG Entertainment's intellectual property, even though GrandMA had all the agreements that they had the rights to all the mobile versions of their titles. So then GrandMA disputes their claims and points out rightfully that they didn't follow the contractually required 30-day notice period, which would have been January 3rd, and that their obligations to pay GrandMA survived termination for everything. But then the story continues even further, where BFG Entertainment failed to actually deliver the reports they were meant to within 45 days after month end. Instead of giving it as spreadsheets, they instead did it just as PDF attachments that were very basic. So basically, GrandMA couldn't actually verify that what they had was accurate for the reporting numbers. And that they just say they had a bunch of detailed spreadsheets, like with all sorts of stuff to clarify everything and make it crystal clear everything was accurate, that they were paying GrandMA properly. But instead of that, they just did PDF summaries that didn't have very many details, and they couldn't actually verify the math was even correct, which, just as a personal guess, I am 99.9% sure the math wasn't correct in it. Anyway, then moving on, they failed to do proper daily average calculations for their reporting, which meant that they lost roughly 30% of the royalties they were meant to for October 2025. And also, they seem to be excluding all the Game Club subscription points and credits, so if someone paid for the game with that, then GrandMA wouldn't get any money from that, because that wasn't like real cash, I guess. Because they have to have revenue as cash received, not Game Club subscription points, even though in the old days they included this in the royalty base for the calculations. But not Big Fish Games Entertainment. No sir, they gotta cut it as much as possible. And then also it says that they suppressed net revenue figures so they wouldn't pass the threshold to have to pay out the $15,000 performance bonus either. And then, just as the cherry on top, they failed to provide any required royalty report for the month of February 26, which was due April 14th. And who knows, the March one would have been probably due a few days ago, and they probably didn't report that accurately either. But of course, that's not able to be included in this document. Anyway, then they just reiterate that the GrandMA had all the mobile rights, not just permissions, full contractual rights, and BFG Entertainment tried to cut them out of it and their intellectual property. At least they did backpedal and say that GrandMA does hold the rights, but that just is another breach that they tried to say they had no rights whatsoever. And even then it says they continued to characterize those rights as revocable, or something that could be taking away, or something that BFG Entertainment could take away from GrandMA, which isn't the case. So then here in the cause of action section, it just basically restates all of what's going on. So GrandMA performed all their obligations, but BFG Entertainment has not done theirs at all and breached several of their contractual agreements. And then they're gonna prove at trial what the damages are. And then talks about, once again, the failure for paying the revenue share properly, and then interfering with their mobile rights. And then I'm not entirely sure this part of breaching the implied covenant of good faith. I guess it means that they were just not being very nice to him. At least that's what it sounds like from this, but I'm not sure what legal argument there is for that. You know, just company not being nice. But I guess there's an implication that, or an expectation of good business dealings between two parties in a contract. This is just what they are arguing. Once again, repeating it. That's the thing with legal documents. It's just so much repetitive going through over and over. And then talks about, once again, that BFG Entertainment didn't do proper accounting or provide the statements they were meant to report. And then it also had a big impact on GrandMA themselves and their expected future business they would be able to do by terminating them. And then in this section, for the requests for judgment, it's called the prayer for relief, which is just a very strange thing, but that is the real legal jargon for it. But I think of a prayer as something religious, not like an appeal to a judge, really. But anyway, what they are praying the judge will grant them is damages and compensation for payment to all of this, for all the unpaid royalties and interference damages, confirming GrandMA's mobile rights as set forth in the agreements, and BFG Entertainment's obligation to continue paying them their royalties and bonuses. And then they also want to have an audit relief requiring them to preserve and produce the proper data for revenue and such, so they can verify their royalties, including the extra game club points or subscription values, and permit periodic audits at BFG's expense. Basically saying they gotta pay for audits to make sure they're doing what they're supposed to. And then also relief, basically saying that BFG Entertainment has to do proper timely reporting and adequate reporting in spreadsheets, not just simple basic PDFs that don't tell much data. prohibiting BFG Entertainment from interfering with the mobile rights through takedown threats, or I guess platform communications means in case BFG Entertainment tries to actually ask the app stores themselves to take the games down, this prohibits them. And proper and correct payment awards for what they're entitled to, as for paying the attorney fees and costs, and other relief, which this is probably the most interesting part, stopping BFG Entertainment from trying to suppress the titles to avoid their royalty obligations. Basically, like if they would delist or minimize GrandMA's games on their website so they aren't advertised or anything. And even they're asking for transfer of all the distribution rights to GrandMA if BFG Entertainment chooses to not exploit the titles commercially and sell them properly. That's really an interesting implication. So I wonder if that actually comes to fruition, would GrandMA become the full owners of the Mystery Case Files games? I don't know. Then it talks about how they can't underreport their calculations or whatever to get out of their proper payments, and choose to allow GrandMA to assign the agreements to another entity without their consent, and require BFG Entertainment to strictly adhere to their provisions for any future changes. And then last but not least, they're requesting a trial by jury. The easiest part of the document to read. And then this is handled by the law firm of Lowe Graham Jones, and specifically by Mark P. Walters as the attorney for GrandMA. And so just looking it up in the King County Superior Court Clerk's office, you can see it was filed on the 11th, and the relevant participants are there, and it says what information was filed by him. And then now this is the kicker for the trial. We have a right in this country to a speedy trial, but just due to the way court procedures work, it is almost an entire year from now, over a year actually, from when it was filed on May 11th. So May 17th, 2027 at 9 a.m. will be when they finally have the trial to see what happens between them. And then you can even see all the deadlines for what goes on in the trial too. Apparently the deadline for a jury demand is February 8th. Well, good thing they at least got on it in their original filing demanding a jury trial. So, quite interesting, and I may post some update videos depending on if any new developments happen within the case. Maybe it'll be recorded online like so many other notable trials recently have like court cam footage. That would be interesting to analyze and break down. And I guess once the trial is actually resolved next year, it will list what the proper judgment is down here. So just very interesting. The lawyer for this is Mark Walters. I'm just looking him up on the Low Graham Jones website. He has quite a big resume of cases, even the District Court of Appeals, and even the Supreme Court argued cases for. And also, he is the only lawyer on the firm's website to have his own little promotional video, which you can watch for yourself if you want to look it up. And then also, it says he was ranked in the top 100 high-stakes litigators for 2018, rated by superlawyers.com, got an AVO rating of 10.0, top attorney for intellectual property law, ranked in Chambers USA 2019, and peer rated for the highest level of professional excellence by Preeminent in 2026. So, seems like they hired quite a notable and really experienced attorney. So, the case seems pretty good that they can at least win, at least from what I see in my analysis as a civilian. And I am all for GrandMA doing this and getting the proper compensation they're entitled to. Because how dare BFG Entertainment just callously fire all of them and then try to even weasel out of any agreements for prior work they did, and instead just sell their games on Big Fish's website continually without even paying the people who actually had any hand in making them. That's not right or fair at all. So, just a very interesting development. I hope that GrandMA is actually able to get the money and agreements that they're entitled to. After going through this whole lawsuit, like, my opinion of BFG Entertainment is even lower than it has ever been. It seems like that's the case. It just keeps on going down lower and lower with each new development that comes out in these months. Of course, it's nothing really new. They already seemed pretty greedy when they fired GrandMA, but from this, they seem even greedier. If there are any updates or further developments, I'll post videos about them further on down the road, but just very interesting, all things considered. I never thought I would be a legal law tuber, but I guess now I can say that that's another thing I've dabbled in on this channel. But anyway, how do you feel about this lawsuit? Do you think it has a lot of weight? Do you think maybe the GrandMA will actually win? Or are you on the side of BFG Entertainment? Who knows how it'll all play out. Leave a comment if you have anything you'd want to add to this discussion. Overall, just very interesting thing to happen to the whole story of GrandMA Studios. So, here's wishing them all their luck in the trial, and that they're able to properly prove that BFG Entertainment wronged them, which, at least judging from what was reported in this complaint, Seems like the contracts of the past were pretty ironclad, and just goes to show the values of the older Big Fish games versus the newer modern Big Fish games. But anyway, that all being said, hope this was informative for you. Like and subscribe if you want, and I'll see you in whatever the next regularly scheduled video is. Goodbye.